Recently, President Biden openly supported exemption of the intellectual property of COVID-19 vaccine for the World Trade Organization, WTO. This became an issue as it means that the USA is willing to give up on the patent rights for successful vaccine development and to allow reproduction of the vaccine. Let's find out about the intellectual property exemption. Intellectual property exemption. The vaccines for COVID-19 were developed at the end of last year. However, there still exists a large gap between the vaccination rates in advanced and developing countries. Accordingly, some people are arguing that the COVID-19 vaccines of certain pharmaceutical companies should be allowed to be reproduced for the whole world to overcome the pandemic. There are opinions that even assert that strong measures of not accepting the patent right for the COVID-19 vaccines are necessary. Normally, the patent rights for vaccines and other pharmaceutical products are protected under intellectual property law. Pharmaceutical products require large development cost, but once developed, they rarely cost anything to be produced. Therefore, in order to allow the pharmaceutical companies to make up their initial costs on the research and development, the laws protect their patent rights. However, such patent right is not always protected. In the rise of an unexpected health crisis across the whole world, such as COVID-19, the patent rights for relevant products may not be protected to allow the vaccines to be reproduced. An exemption of intellectual properties is a legal system that does not accept intellectual property rights for a certain period of time in such a crisis. The same applies to international laws. WTO allows its members to use individual patents without permission from the patent owner under inevitable circumstances. Yet, the country is expected to make appropriate compensation to the patent owner. Such a system of allowing the use of patents is called the Patent License Agreement. Relevant cases and controversies. A similar case is the Patent License Agreement on Calitri and AIDS treatment, executed by the government of Thailand at the end of 2006. Also, the government of Korea also debated about the patent license agreement on the Gleevus leukemia treatment, infusion and AIDS treatment in 2003 and 2009, respectively. However, the agreement did not become effective in either case because of the opposition by the Korean Intellectual Property Office. Patent license agreement always has opposing opinions. The pros value the lives of the people more than the patent rights on certain occasions and argue that the loss of the pharmaceutical companies can be covered to some degree through appropriate compensation. However, the cons point out that although the agreement may resolve the crisis in the short term, it will demotivate the pharmaceutical companies from developing treatments and vaccines in the health crisis in the future. Specifically, they argue that if the patent license agreement becomes effective for the treatments for rare diseases, which requires a significant amount of development cost, no pharmaceutical companies will be willing to develop the treatment according to the market logic.